Evenwel versus Abbott. It is a voting case, perhaps one of the most important in decades, and the issue is actually pretty simple. Two voters in Texas say that their value of their vote is being diluted, that because of the inclusion of so many non-citizens, their vote is worth about half the value of voters in other districts that have large numbers of non-citizens.
The current standard leaves to the states the discretion to decide whether or not to use total population or some other standard, such as citizen population or registered voters. For the most part, most states use total population, and that's partially because of the ease of administration, and the Supreme Court has repeatedly affirmed the use of total population.
The Supreme Court, about 50 years ago in a case called Reynolds v. Sims, created the one person, one vote principle through an interpretation of the 14th Amendment. And what they said back then was that the weight of each person's vote has to be about the same as the weight of other people's votes when they are electing representatives. And so that means that state legislatures like Texas are supposed to make sure that legislative districts have equal population in each district. What the court has never said is which population to use. Is it total population? Is it voting age population? Is it citizen voting age population? And that, in fact, is the issue in this case.
There are different views as to what one person, one vote represents. One is that representatives represent all people, voters and non-voters, citizens and non-citizens, adults and children, those convicted of crimes or those with mental illnesses who can't vote. And the notion being that when we draw districts with roughly equal numbers of population who represent all of them. Or there's the view that the one person, one vote cases were really about the dilution of the right to vote, and that by having one district with a significant number of voters and another district with very few voters, the right to vote is diluted in those districts where you are packed in with a lot of other voters. And so the notion that we should draw districts roughly on the basis of voters rather than just people.
The problem in Texas is that they used total population. And that's why there are large numbers of non-citizens in certain of the districts. The plaintiffs in this case, Ms. Evenwel and Mr. Feniger, are saying that the state should have used citizen voting age population, and then you wouldn't have this huge differential in the voters between different districts.
For many years, the Supreme Court refused to hear these kinds of redistricting claims on the grounds that they were a political question. That is, the Constitution guarantees that each state shall have a Republican form of government. And for a long time, the court refused to hear these claims, determining that it was left to Congress or left to the states themselves to figure it out. It was not a matter for the judiciary. But after Baker versus Carr and a series of cases in the 1960s, the court determined that it could hear these claims under the Equal Protection Clause, and determined that the one person, one vote standard arose out of the Equal Protection Clause of the Constitution. So what had long since been considered a political question, something that was not within the Supreme Court's ken, because the Supreme Court shouldn't really be in the business of developing a political philosophy and requiring all states to follow it. Instead, the Supreme Court has adopted some modest political philosophy at this point of what one person, one vote means and how state legislatures ought to look.